still don't grant the motion to dismiss like you're supposed to. I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house I've been living at for 32 years. The house I've been living at for 32 years, regardless whether it's mine or not, okay?
Do you understand?
Unsupported lie.
Welcome to Sovereign Citizen Legal Encounters. Before we get into the video today, I want to welcome a new member, Mel Johansson. Welcome to the membership. Check out the community post because there's something over there for you. Now, for today, we're back with Eric Martin once again. Eric Martin's case today was definitely wild. You know he likes to talk, but he was with a different judge today. Let's see how that judge handles him, okay? All right? Let's go.
All right, yeah, this is case 24-2448 SM People versus Eric Martin. And this is a scheduled pretrial conference on the charge of domestic violence.
Good afternoon, Your Honor. Nicholas Darren on behalf of Mr. Martin, who appears before us via Zoom. Mr. Martin, if you could state your name for the record, please.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N, family, a private living man, one of the sovereign people.
All right, yeah, this is the pretrial conference. So are you Eric Martin, yes or no?
The living man has been known as by Eric Martin, yes, not the legal fiction corporate entity defendant, though. Spelled it all capital letter his name.
Yeah, you're Eric Martin, in other words.
The living man has been known as Eric Martin, yes, not a legal fiction corporate entity, though.
Yeah, Mr. Dillon.
Your Honor, I was recently appointed to this case. The prosecutor just sent me the discovery. Mr. Martin has informed me that he filed a couple motions with the court. I haven't had a chance to review them, but in discussing them with them, one of them I'd be comfortable just asking the court. I think I can do it orally even. Mr. Martin has been incarcerated for about 38 days now. And under the applicable court rule on a misdemeanor case, if he's been incarcerated for 28 consecutive days, he can be released on a personal recognizance bond. I think that that's appropriate in this case. The delay in this case was not any fault of his or anything like that. It's just he's unable to post the bond. So I would ask that his bond be changed to a personal recognizance bond from, I believe it's the $1,000 bond that he has to post. Additionally, I just, like I said, received all the discovery and whatnot. I would need an opportunity to review that. If Mr. Martin would be comfortable wanting to argue his own motions, I have no problem with that. But I have not had a chance to read them, and I would like to know, I wanted to be able to compare them accordingly to the police reports to see what they were. But I do know that just based off of what he has told me, he's been incarcerated for, I believe my count was 38 days. Today will be the 39th day on a 93-day misdemeanor, which would allow for him to be released under the Michigan court rules.
Hello? Am I heard? No? Hello?
Yeah, do we have the prosecutor available on this matter?
He was just in here. I did tell him I would be raising this issue.
Okay. Yeah, I'd like to hear from the prosecutor on it.
He's in the main session now, Judge.
Okay, Brian, so what I got to say then, before the prosecutor gets a chance to say something?
So, this is on the Eric Martin case, charged as a misdemeanor domestic violence, originally placed on a personal bond. My understanding that he violated bond, and the bond was reset at $2,000 cash because he violated, I think, by having, correct me if I'm wrong, contact with the victim.
Judge, Alex Springer for the people, PNRP 86590. Judge, it's the people's understanding that the defendant cannot go to that address and went to that address, and he was then taken into custody because of that address that he went to, he's not allowed to go to.
So, yeah, and so, Mr. Darren, you want to renew your argument about time period of being in custody on a misdemeanor case and why bond should be personal bond?
Yeah, Your Honor. Just, I'll just briefly, as I did kind of let the prosecutor know, he's been incarcerated for, by my count, 38 days since December 17th when he was picked up. And he's now out, it'll be 38 days, 39 after tonight. The court rule states that after 28 days, he can be released on a personal recognizance bond. There are most of the reasons that it would be denied is based on some sort of delay that's attributable to the defense. I know he's had a couple attorneys, but there's always been the court dates have been set. So I think he would be eligible for the release on the personal recognizance bond.
Yes, something to say, Your Honor.
Just 1 minute, Mr. Martin. We'll hear from the prosecutor.
Yes, Judge, the people, the victim has been sending conversation talks to the victim advocate, and the people would ask if the defendant is released on a bond that the defendant would have a tether placed on the defendant, therefore that it can be rest assured that the defendant makes no contact with the complaining witness in this matter.
All right. Yeah, did you want to be heard, Mr. Burton?
Judge, you just opened a can of worms.
Yes, okay, now, I want to add, under, not only before we get to the bond issue, the cases should be dismissed, which I did file a motion to dismiss already. The court probably just received it, because I sent out not too long ago, like last week. Anyways, under MCR 6.004, subsection C 1 through 6 makes it clear that I have a speedy trial right within 28 days. Since I've been in jail illegally over 28 days, this case should be dismissed based on a violation of my speedy trial right. And based on the court rule I just named off, I'll say it again, case everyone heard clearly, MCR 6.004, subsection C 1 through 6, that is the criteria that is to be followed for speedy trial time computations, not their normal, excluding Saturdays and Sundays and legal holidays. That's always been followed wrongly, but it's not, like I said, doesn't apply to speedy trial. So my right to speedy trial has been violated. The case should be dismissed. So I want that decided on first before we address the bond issue, because as long as that's granted like it should be, then the bond's no issue. But so once the decision is reached on the motion to dismiss, I just filed now. Then once the decision's on that, then I'll address the bond if it's not granted. But that's all I have to say on that for right now.
Yeah, Mr. Ringo?
Yes, Judge, the defendant doesn't get the benefit of picking new counsel, and then when picking new counsel, reach a date where the case will then be dismissed. There's been, I believe this is the third or fourth defense counsel representing the defendant, and if it would be then in the court's inclined to dismiss this outright, then defendants would be able to set the ability to just keep picking new defense counsels, and once they get to 28 days, be able to argue that it wasn't a speedy trial and then have the matter dismissed. So it's the people's argument that the case should remain as charged and addressing bond again, that if the defendant is released on personal bond, it's put on a tether.
I gotta talk to.
Okay, now, what he just said was, I was gonna say it's irrelevant nonsense. I've been in jail since the 14th of December. That's a fact, cannot be disputed. I've been in jail since the 14th of December when I was arrested by Taylor cops illegally, based on no evidence, based on my brother's lying allegation that I assaulted him, which is all it is, it's a lying allegation. But anyways, the fact is I've been in jail on the 14th till now. It's over 28 days. The court ruled again, MCR 6.004, subsection C 1 through 6 makes it clear when you are in jail consistently for 28 days, your right to speedy trial has been violated. It demands the case, calls for the case to be dismissed. Simple as that. Everything else the prosecutor's saying is nonsense.
I'm in this video and I don't understand how I got put here.
All right, we're gonna put you on mute, Mr. Kerr. This isn't your case at this
I'm
time.
supposed to be the defendant or the plaintiff or whatever. Hello?
All right.
Nobody even talked to me. Hello?
All right,
Hello?
so thank you. Yeah, who's speaking now?
That's good.
This is Kurt Martin, the brother,
All right, did you want to comment on this whole matter at this time, Mr. Martin?
no, I don't know. I couldn't even I didn't even know that it was today, the court. Thought that it was yesterday, and I was just called by the prosecutor that it's going on today. I've been hospitalized, and I'm now in a facility that's taking care of me, and so I don't have nothing really to comment about. I mean,
All right, very good.
I just want to make sure that you can see me and I was heard, because there's nobody that see or something.
All right, well, thank you, Mr. Kurt Martin. So, all right, I'm denying the defendant's motion to dismiss based upon his changing of defense attorneys. The delays appear to be, to a great measure, caused by him by violating his bond conditions and repeatedly changing attorneys. That motion is denied. I will allow a personal bond in the case of $2,500, conditional upon a GPS tether and preventing the defendant from going within 1 mile of the victim's residence or having any contact with the victim, as well as no alcohol or illegal controlled substances, coming to court when required, advising the court of changes of address or telephone number, and not leaving the state without the consent of the court, not to possess any weapons and or firearms. And we'll give you another date for court. That'll be, we're gonna need an address for you or phone number, Mr. Eric, for that hearing. Or you can come to the court and get that date. Come to the court and get that date, Mr. Eric.
I have objections to, can I talk now? I have objections to your order now. Can I make objections now to your order?
I did not hear that.
I said I have objections to your order now. First of all, the in objection to your order, no dealing has been attributed to me switching attorneys. That's false. Okay, I have not intentionally said, give me this attorney over that attorney. Whatever they did, that's what they did. You know what I mean? I told Slavin from the jump, yes, I want an attorney. Nothing is attributable to me. So the motion should have been granted, number one. Number two, even if you still don't grant the motion to dismiss like you're supposed to, I object to the bond condition. They violate my due process rights. I don't lose my due process right to be in my house I've been living at for 32 years. The house I've been living at for 32 years, regardless of whether it's mine or not, okay?
Do you understand?
Unsupported
I understand your position, Mr. Martin. Are you telling me that you're unable to abide by my bond conditions?
That's right, because I have no other place to go to.
All right, Mr.
I have no
Martin.
house to go to. And it violates my due process anyways.
Yes, so Mr. Martin is telling me preemptively he will not abide by those bond conditions. Therefore, I am going to change the bond back to the original bond and keep it at the cash bond because he poses a serious threat to the community. He's already demonstrated he will not comply with the bond conditions. And now he's preemptively telling me that he will not comply with the bond conditions I've just set. So therefore, your bond is remaining at what it was before, the cash bond. We will reset the pretrial conference and a notice will be sent out for that next. And
That violates my due process. I'm gonna appeal this now. I'm gonna appeal this to the Court of Appeals ASAP. It all violates my due process. It violates my.
See, Eric Martin kept running his mouth. He would have walked out. Now he needs money to get out. He doesn't learn. He should have let his attorney do the talking, which he did, and just kept quiet. But Eric Martin has to say something every single hearing. He got blasted this time. And he lucky Judge Slavin wasn't in there today because he wouldn't have had no words whatsoever. But I like how the judge muted him at the end. So y'all comment on this because this one was hilarious. I hope y'all have a good day, evening, or night. And I'll see you soon. I'm out.